In fact, you are able to say this because on a platform like Zoom, there is a focus on the screen. And because there is a focus on the screen, there is a focus on the person, you are able to see what that person is doing. You are not able to observe very same thing clearly in a physical session. Say for an example, when I am speaking or you are sitting here, how many of you are actually engaged in this conversation? We could not say with a certain amount of certainty, but if it's just your face appearing, I can clearly see. So probably I can say that this is an advantage of online hearing, that I can see the facial expression. What Mr. Kapoor said that this is a disadvantage, I think this is an advantage. I now can clearly see the demeanor of the witness. And then there are ways of, cutting down the disadvantages he mentioned. But even otherwise, I'm of the opinion that there is no one-size-fits-all approach. You have to look at the complexity of the dispute. You have to look at the monetary amount involved in the dispute. Online arbitration is not an idea post-COVID. It has always existed, as Mr. Kapoor rightly mentioned out. It is just propelled by the COVID-19 pandemic. Procedural hearings were always happening online, even in the litigation. There was always a possibility of online presence of an accused, though it was not very much popular or in vague in the civil litigation. In criminal law, criminal lawyers were effectively using that. So it's not a rocket science, it has always existed. What we need to know that what are the changes which we come. I need to tell you some of the statistics. There is dispute resolution survey which I am doing with the general counsels in order to understand how do they prefer, and it is still an ongoing process, so this is not a certain, but significant number of people have filled. It's versus, so let's understand some versus data. 24% prefer litigation and 27% prefer arbitration. 17% mediation. 17% mediation, remember this is a data before Mediation Act. My sense is after the Mediation Act comes into groove, it is not going to about arbitration versus litigation. It will be only one thing, which is mediation. Mediation is going to be that game changer. 78% prefer hybrid mechanism, 78% of the users. 7.3% only prefer physical hearing. 14.6% prefer virtual hearing. So it's not either or, people prefer hybrid mechanism. So these are some of the statistics I wanted to flag. So thank you so much.
Thank you, Chirag, for that survey, and I'm sure you might have deep dived a lot into it by asking a lot of questions. But I just have a question that what do you basically mean by hybrid, and how it will effectively be done?
When I say hybrid, hybrid can take many forms. It could be mediation plus arbitration. It could be litigation plus arbitration. It could be med-arb. It could be medola, mediation, last offer arbitration. It could be SIAC, SIMC, joint arbitration mediation protocol. It could be anything. There are 20 versions of hybrids. Now, whenever you order food on Zomato, right, and you have a grievance, your food is cold, you open the chat box, there's an automated negotiation going on. That's automated negotiation, and once the automated negotiation fail, then there is an mediator or an arbitrator who is going to take a decision whether you are going to get the refund or you are going to get your food back. So it's that much prevalent, online dispute resolution. Platforms like eBay, they have systematic, like since decade they are using. First, they would use online negotiation, which would be automated negotiation or assisted negotiation, and then there would be mediation and arbitration. And there are many other third-party intermediaries which are doing these kind of online mediations, arbitrations in an hybrid form.
Thank you, Chirag. I have a clarifying question to you, Susheel. So, as a corporate counsel, online versus offline, you've already talked about it. I want to cover one very important aspect, the confidentiality, because many a times, for corporates, there are JV agreements, there are a lot of high-profile agreements, or there are strategic agreements which are absolutely confidential, restricted, not even accessible to many, many even the mid-level management. So in case if we have a dispute and we want to kind of ensure that, this becomes a restricted and we do a closed group arbitration and we kind of, because, it's one of the quality of an arbitration that it can be done in a confidential manner. So how have your experience, or if you have come across any situation wherein you are the general counsel and you have to ensure that the dispute is resolved within the parameters of 4 pillars?
So we haven't encountered any such, situation where in arbitration we had to resort to a very confidential document. So I'm not sure how it's going to be, because we haven't had come across any such situation.
No worries. I respect that, and I'll pass it on to my lawyer colleagues who are actually, practicing. So if this is the same question which I want to ask you both, and from a perspective of a client expectation that it remains confidential, how do you ensure that these online, because so why I'm basically asking you this, that Zoom or Teams can be recorded as well, or let's say for example if I have phone, I can just put a video recording and then do a lot of stuff like that. So how do we as corporate ensures that my discussions are confidential, because many organizations are listed companies, and many and because of being in a listed group, it can create a lot of problem to the public at large because the shares are listed on stock exchange. So over to you, Vivek and Navdeep.
So two things which we do. So both as counsel I insist and as arbitrator I ensure is when you do procedural order number 1, there is a complete section on confidentiality. So it deals with confidential documents, it deals with all online hearings, what happens in those hearings, what can take place. So there is a complete protocol. Now, that is the easier part of it. The more difficult part is sometimes when you are doing a high value dispute in an arbitration, there are some documents that are relevant to the case but have commercial information. Now that commercial information you don't want to, pass on to your competitor who is in a dispute with you. Or it's a situation where there are backward forward linkages, or there's an upstream downstream situation. But again, there is confidential information that you don't want to pass on to them, confidential documents you don't want to pass on to them. So then what can be done is have a confidentiality ring. Now that confidentiality ring will have the arbitrators, will have the counsel, but will not have the client. So there are basically 2 sets of documents that will be prepared. One will be redacted, which the clients can see, and then there is an unredacted version, which I, as a barrister, my instructing law firm can see, but we are not allowed to discuss those with the client. So there have to be, again, there need to be protocols in place. How do you deal with that information in an arbitration so that that confidentiality isn't breached? Again, as you very rightly said, some of this information is very sensitive because if it leaks, it can have an impact on the market as well. So again, protocols need to be put in place. But that seems to be a quite an effective mechanism.
Okay, perfect. Navdeep, your thoughts, and I also want you to add that in case if somebody violates what just Vivek spoke about, what is your thought process and stand about it?
I'll just expand upon what Vivek just said. So there's this concept in American jurisprudence and American statutes about attorney eyes only, there are certain documents that can be marked as attorney eyes only on request of opposing counsel or on request of the adjudicating authority, be it the arbitrator, be it the judge. And you'll find, especially now that a lot of things have become online and a lot of software help is being taken, most of the e-discovery software that you use have options to mark documents as attorney eyes only. Now, as Vivek rightly pointed out, in the first procedural order, it is very, very important to make a protocol for this, which ensures that it isn't being violated at all. As far as violating and the consequent punishment for it goes, it's actually a matter of a lot of debate, especially in America, because attorney eyes only as a protocol or making a confidentiality wing between the counsel and the arbitrators, it's not very enforceable, I must say. In the sense, once the cat is out of the bag, you can't get it in. Once it's out, it's out. So it's a lot of debate. There's a lot of debate whether this is even constitutional or whether this, I mean, in certain jurisdictions, whether it infringes upon the rights of parties to have all the information, right to information. There are a lot of things in that. But on staying on topic, I think with online arbitration, with a lot of software help, the logistics to ensure that something remains confidential have only expanded and have only become stronger. I mean, gone are the days when a Sharpie was your best friend and you just redact with a sketch pen and be done with it. And this is much, much better. Thank you very much.
Thank you, Navdeep, for that honest and